We're going to get the morning started this morning with our panel on pretrial detention and bail reform. Our moderator is a member of our Judicial Advisory Board, Justice Jim Worthen. He's been the Chief Justice of the Texas 12th Court of Appeals since 2003. And prior to that, he served the state of Texas as a justice on the 12th Court of Appeals in Tyler. He's a 7th generation Texan, but he does have a little bit of a connection to Virginia. In addition to his degrees from the University of Texas at Tyler and his JD from South Texas College of Law, he does have an LLM from our very own University of Virginia. I'm pleased to welcome Justice Worthen, and he will get us started with the panel.
Thank you very much, Paula, and good morning. Well, to release or not to release? That is the question. Now, I think it's probably appropriate that we begin this morning with a takeoff from William Shakespeare, because to release or detain goes back almost 1,000 years in our common law tradition. In England, during the 1100s, not too long after the Battle of Hastings in 1066, a system of bailable and non-bailable offenses developed. But by the 1270s, King Edward I began hearing rumblings from throughout the hinterlands that the system was not fair. So he had what was called the 100 Inquests in 1274 to investigate this situation. And following these 100 inquests, and I'm quoting from the summer 2018 edition of the ABA's Judges Journal, Parliament enacted the Statute of Westminster in 1275 to establish criteria governing bailability, largely based on a prediction of the outcome of the trial by examining the nature of the charge, the weight of the evidence, and the character of the accused. That sounds very familiar to what some of our professors were talking about yesterday. You notice that our professors yesterday, Professors Harvey and Doliak and Natapoff, they just couldn't help getting away from their assigned topic and start talking about bail and how bail needed to be reformed. And they just could not resist that. And then also at noon yesterday, we heard Attorney General Herring of the Commonwealth here explain why he is getting involved in this issue. Now, this very morning, George Mason has assembled an all-star panel to lay out pretrial detention and bail reform as it currently stands here in 2018. And I think our panel is going to really be able to discuss this from just about every major viewpoint that we want to see. So let me introduce our panel so they can get going. First, if you were here yesterday, you heard starting out with our very first speaker yesterday morning, Professor Luna, and then Professors Harvey, Doliak, and Natapoff all referred to Megan Stevenson, Professor Stevenson here at George Mason. And so I think you can understand why she is a superstar in this topic of pretrial detention and bail reform. So Professor Stevenson is here at George Mason University, and of course, in our assigned readings involving what Judge Lee Rosenthal had written in the O'Donnell versus Harris County case, Professor Stevenson, her work was heavily cited by Judge Rosenthal in that opinion, and then as well as at the Fifth Circuit. And also, I believe another one of our panelists, Paul Heaton, was involved with that as well. So then, besides Megan, we have Jeff Clayton. Jeff Clayton is the executive director of the Bail Reform Coalition here in the United States. He is a graduate of one of our fine institutions in Texas, Baylor, and served much of his professional career before he became involved with the Bail Coalition in Colorado, and that's where he got his law degree there in Denver. And finally, the last person on our panel is Walter Olson. Walter was with the Manhattan Institute for 35 years. 25, yes, I'm sorry, 25 years. You're not that old. 25 years, and then is currently with the Cato Institute, where he's been for 5 years. And before that, before he was with Manhattan, I believe he was with AEI, wasn't you? So anyway, we have, what would a panel be without someone from a think tank? And we have someone who is par excellence with serving with think tanks. So we've got a really terrific panel here, and so I'll turn it over to Professor Stevenson. Oh, I'm sorry, I forgot. Well, I'm sorry, I mentioned you obliquely there, Paul, but we'll specifically talk about you. Paul is the director of the Quattrone Institute at the University of Pennsylvania, teaches also at the law school at the University of Pennsylvania, and is also an economist, as is Megan. And he's been cited quite often in as well, by Judge Rosenthal, numerous law review articles, and has written even briefs, been involved in briefs, Friends of the Court, for the Supreme Court. So again, someone very qualified on this topic. So with that in mind, we'll turn it over to Professor Stevenson.
Hello, everybody, and thank you for engaging with all of us in the fascinating discussions that have gone on over the last day and will continue today. So I've been asked to give a brief overview of bail reform issues. I'm going to keep it short, or at least the setup short, because I think many of you are familiar with some of the topics in this area. Certainly, Attorney General Herring gave a pretty compelling pitch yesterday for why this is an important topic. I did want to briefly touch over some of the statistics again, because for me, they are astounding. So the pretrial population that are incarcerated make up 3/4 of the jail population, and virtually all of the growth in jail populations over the last 20 years or so. People who are detained pretrial make up 1/5 of the total incarcerated population in the United States, including state and federal prisons. In fact, there are more people detained pretrial than are currently serving at any point in time, that are currently serving time for a drug sentence. For a variety of reasons, including this massive scale, it's important to get the pretrial decision right. So currently we're in the midst of a reform movement that is among the biggest seen in many decades. There are reform efforts taking place in almost every state, almost every large jurisdiction, and many small ones as well. And interestingly, it's a reform movement with bipartisan support. And the motivation, depending on the locale, can come from a variety of different sources, from legislatures, from the judiciary, from district attorney or attorney general's offices, sheriffs, defense counsel, civil rights litigator, and of course, advocates and activists. So the ideas behind the bail reform movement is to get rid of some of the things that people think are currently bad about our current practice and replace them with practices that people hope will be better. So one of the most prevalent aspects of the bail reform movement is moving to eliminate or dramatically reduce the use of monetary bail. And this is motivated by a variety of things. First, many people believe that the use of monetary bail results in a de facto discrimination on the basis of wealth. This raises constitutional issues. It also raises simple moral and ethic issues. Because of the correlation with wealth and race in our society, it can result in racial discrimination. I have a study out, or a study that is almost out, that decomposes racial disparities in pretrial detention in Philadelphia. I find about 2/3 of it come from the fact that Black defendants have higher bail amounts, but that the final third comes from the fact that conditional on the bail amount, Black defendants are less In a variety of jurisdictions around the country, different researchers have shown that there can be very high rates of detention, even at relatively low rates of bail. So money bail is serving effectively as a detention order, but it's not simply a detention order, it's this sort of curious probabilistic detention order. There's one thing to set bail at $500,000 when somebody has been accused of a scary crime and the judge wants to ensure that that person remains behind bars and is prevented from committing another crime during the pre-trial period. It's another thing to set bail at, say, $1,000 and you have, I don't know, maybe 40 to 50% of people freed and the other 50% remaining. What is the rationale behind that? Furthermore, it's an inefficient use of resources. We wind up detaining people that pose relatively low risk but can't afford to pay bail, while releasing people that have been able to access resources to pay the bail but might pose a serious danger to society if released. Another part of it is that the use of monetary bail sort of confounds two goals of the pretrial decision. One of those goals is preventive detention, preventing people from committing crimes during the pretrial period. The other goal is ensuring appearance. And in the current use of monetary bail, they're kind of trying to do both things at the same time. And that winds up not being very effective. I personally am persuaded by the idea that a released person might have stronger incentives to show up in court if they have money on the line. But on the other hand, I'm not persuaded by the idea that this justifies detaining people de facto because they can't afford to pay $1,000, a couple $1,000, or even less, $500, a few $100 in bail. And I also want to note that the United States is one of the only countries using a pretrial system which is dominated by commercial bail bondsmen. There are many other countries in the world that have figured out how to make their pretrial system work without this particular unique practice in the United States. One of the other major complaints about the current practice of bail is a lack of due process before someone is detained. Current bail hearings around the country often last a minute or two at the most. There's no defense counsel, there's no evidence presented. They use, it's common to use these bail schedules in which bail is, say, you start with $1,000 if it's a felony, and you add, say, $500 for every misdemeanor conviction on the record, or some sort of kind of grid that gives you the bail amounts, which neither tailor to a person's ability to pay nor to the specific details of the circumstance. So these are the things that many bail reformers want to see changed. And among the new practices that have been proposed, there's a variety. So one is if we want to get rid of money bail, but still feel that there are some circumstances, or at least some people who we want to detain pretrial, you need to expand the capacity for preventive detention. And that can often result in, I am going super slow, can result in, or require a rewriting of the state constitution, which is controversial. And many advocates argue for careful limits on preventive detention and say that it should not be authorized for people that are charged with misdemeanors or low-level felonies. In other words, detention before trial or without trial should be a carefully limited exception. So the other, one of the other things people are arguing for is ensuring due process for those who are detained or otherwise have liberty restricted. So that entails ensuring access to defense counsel, having an adversarial hearing, some presentation of evidence on the case at hand, a right to discovery, etc. Another part of this movement has been implementing alternatives to detention. So this can range from automated text message reminders, expansion of pretrial services, pretrial supervision, electronic monitoring, and so forth. And the evidence on these vary. There's a lot of good evidence that simply sending people reminders to come to court can be very effective in reducing pretrial failure. Other things, such as the generic pretrial supervision, require weekly meetings and so forth. There's really no good evidence that that's hugely effective. Finally, one of the prevalent themes here has been adopting risk assessment algorithms. And I wanted to list this one last because it is controversial, and in many people's eyes, it has been tied to the bail reform movement, that we're going to get rid of money bail and implement risk assessment algorithms. And that's certainly been a dominant model in many jurisdictions, but it's not the only model, and it doesn't need to be a central part of it. Proponents argue that they increase efficiency and reduce idiosyncratic variation. Critics argue that it reduces humans to numbers and expands assembly line style justice and can increase racial disparities. Empirically, we don't know a lot about what the impacts of adopting risk assessment are. In some research that I've done, I would argue it's demonstrated that in Kentucky, at least, it was not a silver bullet, but it also didn't result in the huge increase in racial disparities that some critics had predicted. So thank you so much, and on to Jeff.
All right, I'm going to do my timer here. There we go. For me, it all starts with preventative detention. Those who don't learn history are doomed to repeat it. So go read congressional record from 1981 to 1983 and read what Professor Dan Fried said about preventative detention. That's the alternative to the money bail system. You can say, I don't like the money bail system, we need to get rid of money bail, but what's the alternative? The alternative is a system of preventative detention, which to me is an evil system. And although Justice Scalia was in the majority in the Salerno case, I think if you look back on it, he would decide the case otherwise. And we've seen the expansion of pretrial incarceration triple in the federal system under the Bail Reform Act of 1984. We've seen the large expansion of detention in New Jersey, starting around 30% motions filed in all cases. Now it's a majority, more than a majority. And so if you don't understand preventative detention, the system of preventative detention, you don't understand bail reform. And I would encourage all of you to go read the dissent in Salerno, again, Justice Thurgood Marshall, and realize that the ACLU then fought the Bail Reform Act of 1984, and for the last at least 10 years have been advocating for these preventative detention policies. And I think people finally woke up when Senate Bill 10 in California was passed, and that's why myself and 55 civil rights groups are fighting in California to stop the system of preventative detention. There was an article that appeared in the Northwestern School of Law, a journal in 1985, and the title was Preventative Detention, a Constitutional but Ineffective Means of Crime Control. And everybody can play the Willie Horton card, which we certainly do on both sides of this issue many times, but the reality is new crimes while on bail are usually around 5%, which most people don't think about. And so we're gonna have to lock a lot of people up to stop a few people from committing crimes. The system of cash bail, do I defend the system of cash bail? The term cash bail alone is one, and I always tell reporters, we're against cash bail, and they scratch their head, and we're in the commercial paper market, so we don't want any cash going around. And obviously, if you've read State v. Batson in Washington State, where the Washington Supreme Court held, and there's split in authority amongst the states, that you can't do a cash-only bail, that the defendant has to have the choice. Non-monetary holds are something that are ignored largely in this country. We can talk about all kinds of statistics about who's locked up under pretrial detention, but non-monetary holds drive more than unposted bails, and I'd love to see some research on that. The Khalif Browder case is thrown in our face as an industry many times. But Khalif Browder wasn't bailable. I went round and around with a reporter on this, but he was bailable for about 7 hours. And of course, for those who don't know the story, he was on probation for stealing a backpack. He spent 3 years in Rikers Island. He spent 400 days in solitary confinement. And ultimately, when he was released, he killed himself. And of course, the system breaks down in many ways. First of all, allowing juvenile offenders into Rikers Island is a problem, one I consider abhorrent, but the reality was a non-monetary hold on a low-level probation case is what left him in. So Those issues, I think, we don't give enough attention to. This debate is as old as time. Alexis de Tocqueville criticized the cash bail system in 1835, and the arguments are largely the same. For me, the right to bail is important and is a way that we challenge the state. And as Professor Fried has said, sufficient sureties has always meant money in this country. Love it or leave it or go to preventative detention. This is a seminar on law and economics, and so benefit cost analysis in this space is lacking severely. Professor Stevenson's actually doing probably I guess I'll call it yo woman's work, can I say that? Is doing amazing work in this space, looking at the benefits and the costs. Most people, don't even look at what is the cost of a failure to appear. In our panelists, or in our moderator's home state, economic analysis has shown that one failure to appear costs the state of Texas $1,775. So we can argue all day long that, well, this person shouldn't be in jail because that's costing us, but if we know he's not going to fail to appear, well, maybe it's cheaper to actually leave a person in jail. But until that analysis is done, we have a lack of understanding on this issue. And I think also the impact of a new crime and what that costs the victims and what that costs, obviously the state. And so this is the Antonin Scalia School of Law. So you can't come in here to the Antonin Scalia School of Law and not tell your Antonin Scalia story. And so many years ago, I applied for a Supreme Court fellowship. There were 250 roughly applicants. I made the final 8. I went to the great hall of the U.S. Supreme Court to have dinner. There was a cocktail reception before. The point was to lobby the panelists in your favor. And so standing next to me was one of my compatriots who was a professor at the University of Chicago School of Law, and I figured, I'm not academic enough to get this. This guy's probably got it in the bag, but oh well. And so Justice Scalia walked in, and I turned to the Supreme Court security and I said, what the hell is he doing here? And the security guard said, well, typically when there's an event, he just shows up. And so I turned to Todd and I said, Todd, I'm going in. And he said, what do you mean you're going in? I go, well, I got to go talk to Justice Scalia. I mean, who's going to miss this opportunity, right? And so I went over and I said, and at the time, Chief Justice Bender of the Colorado Supreme Court, who I represented, had just become Chief Justice and had just met Justice Scalia the prior week. He was a shorter guy, only 6'3". And I walked up to Justice Scalia and I said, Justice Scalia, I'm Jeff Clayton from Colorado. And he said, they all grow them that tall in Colorado? And I said, well, yeah, Justice. And I said, this is Todd, introduce yourself. And he said, well, what did you guys do today? And I said, well, we started off over at the Sentencing Commission. He said, Sentencing Commission? That's unconstitutional. Well, at least I thought so. And then he said, well, what did you do next? And I said, well, Todd, why don't you tell him what we did next? And so Todd said, well, we went over to the museum, and Justice Breyer was on a panel talking about media and the courts, and he said, well, what were all the questions about? And he said, well, it was all about cameras in the courtroom. Terrible idea. I said, yeah, Justice Scalia, we've got the Oye project. We're all good. We don't need that. And he scratches his head and he goes, okay, Oye. So I'm down in Cajun country. We're bird hunting, and we have a guide, and his name's Oye. It's French. Get it? And so I'm trying to laugh and wrap my head around it. And I said, yeah, I do get it. So what a great man, and what a great guy, and certainly was more than gracious in talking to us. So thank you.
Thank you very much. Thank you very much, Jeff. Before you begin, Jeff mentioned something. He mentioned about Alex de Tocqueville talking about our bail system in 1835. The same article that I referred to earlier, the ABA Judges Journal from this summer, mentioned about when the very first unattainable cash bond was set in America. It was 1835. It was for the defendant who was accused of attempting to kill President Andrew Jackson. So that's kind of interesting, I thought.
Yeah, and for those of you, you probably remember Deep Thoughts with Jack Handey. One of his favorite ones was, I wish the president was a robot, because when he came to town, we could all take a shot at him and not feel too bad. And a lot of people would agree with that these days. There's my time.
Okay, Paul, carry on.
So I want to pick up where one of the points that Jeff made about the need for analysis and understanding of the cost of benefits. And I'd like to use my time to just give us all a sense of what the stakes are here. And to do that, I'm going to talk about a new generation of research. So it turns out we actually know a lot more about the issue of preventive detention and pretrial detention than we did even just a few years ago. There's been a raft over the past couple of years of high-quality research studies which help us to better understand what happens when we detain people. I'm going to talk about what those teach us, and we'll think about what some of the legal implications are. So this bail has been around for a long time, so haven't we studied this? Yeah, there's been research on the topic of what are the effects of detention, but I think one of the things that differentiates this new generation of studies is, often policy in this area is driven by anecdotes or single cases. Justice Worthen and I were talking about Texas right now has some legislation because of an unfortunate incident involving the death of a state trooper. Often that's how we're making policy. The research, on the other hand, is able to look at large administrative data sets, and there have been studies that have looked at a number of jurisdictions: Pittsburgh, Philadelphia, Miami, New York, Houston, among others. And they're able to look at how the system functions as a whole, looking across tens of thousands or even hundreds of thousands of cases that are resolved in the criminal justice system. I think another differentiator of this research is, as researchers, we want to think very carefully about correlation versus causation. And we know that there's a lot of differences between the people who get detained and those who get released, and we want to account for those. This new generation of research uses what researchers would call quasi-experimental methodologies to try and really nail down what's the effect of detention. So in some of the results I'll show you in a minute, you want to understand I'm not just reporting what are kind of averages between people who are detained and released, but what I'm showing you is if we were to take a pool of defendants and in one state of the world detain them, what do we think their outcomes would look like versus that same pool of people and if we were to release them. So that's what we're actually able to measure in the same way that we measure the effects of drugs using, say, clinical trials. So I think a third characteristic of this research and why it's particularly important to understand is there's been a lot of focus on, what happens in that period during the case, maybe the resolution of the case itself. But this new generation of research also allows us to look further on and look, a year down the line, 3 years, 5 years, and look at a range of outcomes such as future crime, such as people's economic activity. So it gives us a broader idea of what the effects of detention are. So what do we learn from this research? First of all, what we learn is that detaining people actually affects the guilt-innocence determination in a causal way. So work that Megan and I jointly did in Houston, other work there on the slide, you can see results from a study focused on New York, or one of Megan's work, focused on Philadelphia, demonstrates that there's an increased probability of conviction, and often that comes through guilty pleas. And if you think about the incentives, right, once you're detained, you start accumulating punishment, and particularly for low-level offenses, at some point it's very easy to have accumulated your entire expected punishment, and at that point, if you want to assert your innocence, you're going to actually have to prolong your amount of detention. And so the system can embody some perverse incentives. We also see that it affects the sentences that people receive. In some examples, as in Megan's work in Philadelphia, dramatically increasing the length of sentence. So if we're going to choose to detain people, we have to recognize we're choosing to change whether or not they're going to get convicted for the immediate offense. So another thing that we see is that there's evidence that under some circumstances, detention can ultimately turn out to be criminogenic. So we might, in the short term, get some benefits in terms of incapacitation, and I think it's reasonable to think about and be concerned about trial or crime that might occur in the pretrial period. But what this research suggests is, as we look further out, what can ultimately happen to many people is is as a result of some of the things like what we heard the Attorney General talk about, people losing their jobs, losing housing, having impairments in their family relationships, that can ultimately lead to additional crime. So work we've done in Harris County demonstrates that. Other work by Nolan Pope and Emily Leslie focusing on New York City demonstrates that there's actually a causal increase in crime when people are detained. So if we want to think about public safety as a rationale for detaining people, we need to recognize that one of the things that we might be doing is actually pushing people into committing crime. So a final result that I want to share with you comes from some fantastic work which has been done to try and link criminal justice records to IRS tax records so that we can understand what some of the economic impacts of detention are. So this work done by Crystal Yang, Jacob Golden, and Will Dobby demonstrates that when we detain people, that actually reduces their likelihood of employment. You can see a decrease of about 11 percentage points, and it actually lowers their earnings. So if we look 3 to 5 years out, people earn actually about $1,000 less as a result of detention. So the bottom line here is that detention has a lot of adverse impacts, and I think that that has some important legal implications. First of all, what it suggests to me is that if we're going to detain people, we need to be upfront about it, and we need to ensure that there's a very robust set of processes to ensure that we're minimizing the use of detention. So I think one of the criticisms of cash bail systems as they're currently implemented in many jurisdictions is we say, well, hey, as long as we're assigning an amount of cash, we're not really detaining the person because they could always pay the bail. But if the reality is they're going to be detained, I think we need to recognize that we're imposing the set of harms that I've just described by the research, and we need to make sure that we feel okay about that. And we need to ensure that there's sufficient process, that we have individualization, that we have a robust adversarial process to ensure that we're not imposing these harms unless the situation really warrants it. I think there are also implications, as the Attorney General mentioned yesterday, about right to counsel, and to what extent should we think of these individual determinations about bail amounts as warranting counsel. I think there's a lot of evidence that that's going to affect ultimately what happens in the case, and so there's an argument that people need to be represented there. And then finally, I think that one of the things that we have to do in terms of making judgments about the constitutionality about these systems is balance interests. If you think about applying different levels of scrutiny, for example, and I think that given the evidence that we have that these systems can actually be criminogenic, it can't just simply be, well, hey, we're preventing failures to appear, we're reducing pretrial crime. We have to take into account some of these other harms. So where do we go? I think that the big question is, if not pretrial detention, what? And so what are the alternatives? I think preventative detention, as Jeff mentioned, is something that people have proposed in some situations, but I think there are a lot of other options that we could think about. And one of the things I'm looking forward to discussing with the panelists is, what are the pros and cons of these various options? And as Megan mentioned, what role should risk assessment play, if any, in this process?
Great. Well, thank you. I, too, will quote Justice Antonin Scalia, who, can you hear me? Am I loud enough? Who used to call himself a faint-hearted originalist. He was going to pursue originalism when that didn't mean pulling down the columns of the temple when it was more or less practical. But he knew perfectly well that there was some originalism that was just going to be too disruptive, and he was accordingly faint-hearted. Now, I would describe myself as a faint-hearted bail reformer. I do like the idea of expanding non-cash alternatives. I think that the case has been well made for on several different dimensions there, and I think the strongest of all arguments is that other countries do it that way, and they can't all be wrong. They can't all be on the wrong track. At the same time, from my background in economics, I am trained to look for unintended consequences, and I can almost guarantee you that you are going to see a bunch of them as the bail reform movement moves on. In fact, what got me interested in this debate was observing a couple of the unintended consequences. First, in my own home state of Maryland, where reform began somewhat willy-nilly or pell-mell a couple of years ago when our Attorney General consulted with the judiciary and issued an opinion saying that constitutionally, at least under the Maryland Constitution, the old way of assigning bail would have to go. Judges, quoting here from my summary, may not set financial requirements if there is a reason to believe the defendant cannot pay, and unless they hold a suspect without bail, they must impose the least onerous conditions. Now, when we heard about this, most of us, thinking of the different analyses of cash bail as unfair to poorer defendants, were expecting the jails to get emptier. But in fact, in Maryland, the reverse happened. The first report came out in the Frederick News Post, finding that the share of defendants held without bail had increased from 10% to 14%. The Washington Post later on looked at I believe, a longer time period and found a jump that was even bigger than that. Meanwhile, the failure to appear rate, yes, it turns out that failure to appear is very incentive sensitive, was up 5 points from about 10% to about 15%. And this went on, unfortunately, for some time. Now, those close to the Maryland scene told me that there was an understandable reason why this was happening, which is that in most states and jurisdictions that have successfully had bail reform, there has been a design and installation of the replacement institutions, of the guides and algorithms for determining likelihood of reappearing, the monitoring, whether it be phone calls or electronic bracelets, the tie-ins with probation systems. This had been done in other places that had had a better experience with bail reform. But Maryland, the people making decisions for that end of it were different people. It involved our state legislature. Now, I don't mean to say anything critical about our wonderful state legislature, but they dithered. We have a 3-month term. They dithered for a while. They thought maybe they would try to override what the Attorney General did, but they didn't have the votes to do that. Some people wanted to get to it rapidly and install pretrial services, but there wasn't enough urgency about that. So basically, nothing much was done. Some counties acted, but so you had judges who had the old methods taken away and were not given new methods, and lots of bad things began to happen. In particular, lots of people were being held who would have been freed before the change. Now, as I understand it, things are getting back on a better track as people catch up with what should have been done beforehand, but it's the old advice, which is before you begin demolition on your house, make sure you've got a place to live instead. And the same thought occurred to me when Google and Facebook announced that they were no longer going to take ads for bail bonds. And it quotes, Google quoted one group's representative hailing the largest step any corporation has taken on behalf of the millions of women who have loved ones in jail across this country. Now, my first thought was maybe they could have given some money to a community bail fund and gotten some tangible benefit for those women trying to get their sons and brothers out of jail. But beyond that, I mean, look at what they did. They took away the ads. Now, I figured I'll bite. How does it help those mothers to not inform them that there is a way to get their son or brother out of jail that very night? How does it help them to take away the realization that there's competition and several people so you don't have to take the first person that your sister-in-law recommends? So I don't think that Google announcement helped one bit. Once again, it was jumping into the demolition of the old system before the construction of the new. And the Salerno case was mentioned. This was the constitutional one, upholding pretrial detention. I myself think that Justice Marshall, in dissent, really had a point when he said that the mention of bail in the Constitution, which is that it shall not be excessive, is a suggestion that they were concerned with defendants' rights and that it's just a little bit too clever for the majority to have said, oh, well, there's no worry about excessive bail, you're just not going to be given bail at all, and so you can't call that excessive. Wait a minute, this is too clever by half, and it postponed the reckoning with the question of whether or not there might be a better case for generalizing the rule against excessive bail to a rule against excessive pretrial detention. And and that's why I get around to a couple of final points. It has been suggested, and I'm fascinated by the suggestion, that rather than take away cash bail with a demolition as we install a new system, that we instead allow them to operate side by side, that we create that we give judges the algorithms, that we create the various methods for letting people check in or be monitored in order to show appearance, something that will often appeal to people who could not afford cash bond. There are probably things we could do about the risk of reappearance, although it was Alex Tabarrok of the economics department at George Mason here who did, along with Eric Helland, the classic study that, not really surprising, the use of bounty hunters by after people skip was considerably more effective at getting people back than relying on local sheriffs. That was what was it, 6 or 8 years ago? I mean, 90% of the work of economics is to confirm what you already intuitively knew. But it is still useful to have been warned in studies like that if you do away with the bail people, you also have to worry about institutional substitutions for the bounty hunters and the way in which bondsmen chase them down. So yes, by all means, let's explore these things. But back during the 80s, I think, and 90s, there was a bit of a fad for what they used to call the multi-door courthouse, which is rather than just go up the steps to the forbidden courthouse, there would be a door for arbitration and a door for mediation and a couple of others. Now, I'm not sure how well that worked out, in part because lawyers sometimes realized that they could play for advantage by, pretending to want one door when they were actually stalling for another. But it did give me the idea that if multi-door entrance to a courthouse is important, it might be even more valuable for constitutional principles to have multi-door exit from detention. Thank you.
Okay, thank you very much, Walter. I think first, let's see if any of our panelists would like to respond to comments made by one of the other panelists. Does anyone have any responses they would like to make?
Well, I had a question for Paul, which is in the interesting studies about how pretrial detention correlates with more trouble holding jobs afterward and various other bad outcomes. How did they standardize? Obviously, these were two groups that were different in the first place, those that made bail or otherwise were not detained. They did standardize on that, right? But it must have been difficult.
Well, yeah, so I mean, the predominant, there have been a few different research designs, but the predominant research design is to actually exploit which is to say, in many jurisdictions, you randomly assign magistrates, and people vary in the stringentness with which they apply the schedule. And so you use that variation to try and build groups of people who we think ought to be the same, but who vary in whether or not they get detained.
They probably could check some of the statistics to verify that the two groups were.
Yeah, exactly, yes. Megan has spent many hours thinking about that problem.
I'd just bring up Texas. Obviously, the name Damon Allen is now on the Law Enforcement Officers Memorial, which is close to my heart. I defended 100 police officers who discharged their weapon into suspects. My dad was a career cop. His friend was killed when I was a young boy. But the Damon Allen Act, I think, is worth raising, which is being brought by Governor Abbott, because we can talk all day long about the algorithms, and I'm sure we'll bring that up, which is really just a scoring of the information. But in Damon Allen's case, the suspect had a prior conviction of assault to a police officer and was on bail for assaulting a police officer, and the Justice of the Peace had no criminal history information on the suspect and released him on his own recognizance. And that doesn't mean, well, okay, he would have posted bail and done it anyway, which would have been the argument, but he may not have. And so what we're seeing and what I advocate for is complete criminal history information for judges. Don't give the judges the score, give them the information. You can score it if you want, but make sure that they at least have the information. And we're seeing major gaps in criminal history information. For those of you familiar with the Lautenberg cases, 21 states aren't uploading domestic violence convictions. And so for me, as an advocate on this issue, I advocate for complete criminal history information because around the country we see that that's major league lacking.
I wanted to say, so Walter made the comment that 90% of economics is telling you what you already know. I don't know what the numbers is, but I feel like there's a significant portion of economics which is telling you that what you thought was wrong, and things that you thought were going to work didn't quite work out that way, and that it's hard to predict the future. There's unintended consequences. And for Professor Doliak ended her talk yesterday by saying, plan to move forward as if you're going to fail, try to fail quickly, try to learn from your mistakes, move forward, pick yourself, dust yourself off, move on, advance. And I many people have brought up, or particularly Jeff has brought up and Walter as well, that some of these sort of fixes for what is in my mind, a non-functioning system, we don't know if they're going to work. And maybe, there is this problem that we're going to result in this, dramatic expansion of preventive detention, or we need to figure out how to get people to show up in court. I don't argue with any of these things. I think that as we move forward into bail reform, there is such a thing as bad reform. And, but that's no excuse for not moving forward. That's no excuse for not trying things. And as we move forward and we try things, we evaluate. We say this worked, this did not. You adjust, you continue to move forward, and that's what I advocate for. I think that any of the concerns that are raised, they just don't reach the bar of being able to justify a system in which we take away people's freedom on the basis of a 1 minute long hearing with no defense representation, on the basis of barely meeting the probable cause standard, and using a system that results in de facto discrimination on the basis of wealth and, therefore on the basis of race. And so I at the same time agree with everything everybody has said up here, and yet don't want any of it to take away from, the sort of forward momentum that I currently think is exciting about the bail reform movement.
I just wanted to add one thought on the due process question. So you may have seen that in these bail cases, there's a lesser-known attorney by the name of Paul Clement involved. And I cold called him, actually, believe it or not. I just picked up the phone and called him. Got his office, and they said, call him at home. They gave me his home number. I should have saved it, but I didn't. Of course, he's a Green Bay Packers fan, but don't hold that against him. So I called him, and I explained what was going on in this case, as he hadn't heard of it. And he said, Jeff, that's a due process problem. That's not a bail problem, that's due process. And he was quoting cases and all this sort of thing with this photographic memory. But we have seen the due process and bail issues around the country as a major problem. And of course, now advocates call this the third generation of bail reform. For us, we're calling it the fourth generation of bail reform, and we are advocating for change. And the biggest one is due process. We're seeing, Harris County, Texas was the best example. You didn't have an attorney, and if you started to talk, you were ordered to shut up. That's not due process. The Walker versus Calhoun, Georgia case, the guy, Mr. Walker, was public intox, walking on a highway, 13 days to get in front of a judge to argue his $160 bail. And so the due process issues are real. An attorney out in California was telling me that, it's about 7 days to get a bail review hearing from a schedule. And if you're familiar with the bails in California, they're pretty high. And so we've seen, conflation of right to counsel, meaning the defendant in jail doesn't know that they have to file a motion to get a bail review hearing. They don't realize that. And if they don't have counsel, they're not going to figure that out until sometime later. And so we've seen that. We've advocated for that. And obviously, I've advocated for the fact that, use a bail schedule to allow people to get out if you have to, but best practices would be setting bail in every case with counsel and in a contested hearing. That would be best practices. I met with the White House yesterday, and that's what I advocated for. I said, there's two things you need to do. One, don't fund the court system based on fines, fees, and bail forfeitures, because that creates a perverse incentive, number one, and create federal grant dollars and dollars to stop that. And the other thing is the right to due process. You've got to advocate for that. And if you do those two things, you'll make more progress on this issue than anybody else has in a generation.
You know, the public is the one who holds we judges accountable, and they expect us to get it right. So what are our options?
For getting it right? Well, we're not getting it right. So we're not getting it right now. It's definitely not. This is not, we have not nailed, we have not perfected the pretrial system in the United States. So from there, you try new things. You move towards, so I would love at some point to be able to sit down with Jeff Clayton when he's not, either when he's got all the microphones off and he's completely off the record, or when he's left the job, because we agree on a lot of things, except that we come to this point where he says, everything he said about due process, I'm totally on board with him. And then he says, and then you use it to set monetary bail. Now, I'm fine with using monetary bail as an incentive for people that are released, to encourage them to come back from court. But that's not the way it works. You set the monetary bail, and then you have some people that get out, you have other people that don't get out, and that's where detaining people on the basis of failing to be able to come up with whatever amount of money the judge has set that's where it just doesn't make any sense to me. It doesn't make any sense to me. So where do you go from there? Where do you go from there? So at the very least, you could, if you wanted to keep cash bail in the system, you could do something as simple as just say, hey, what do you have in your pocket right now? You got $20 in your pocket? You got $50 in your pocket? Let's start off with that. If you want to keep cash bail in the system, that's one option. I personally know, I'm not saying that I'm the representative defendant that you will see, but I make a lot more money than probably most people that are coming into your court arrested. If I have $20 on the line, for my dentist appointment, I make sure that if they're going to charge me $20 to miss my dentist appointment, I make sure that gets into my phone. I make sure that I remember. So as part of it is making it salient to people, making sure they remember. There have been experiments showing that if you just change the format of this is in the citation context, so it's slightly different, but you change the format of the ticket, you put the date and the time on the top of the card, you put the fact that there might be that there will be an arrest warrant coming out for if you don't show up on the top of the ticket. People show up. If you send automatic text message reminders, people show up. You can drop the failure to appear rate by about 1/3 just based on interventions like that alone. That being said, I don't deny that there might be trade-offs. If you release more people, you might have an increase in failures to appear. Are these benefits worth the cost? In my mind, they are. But that's just a reality. And then finally, I just want to bring home the point again, which is that very, very, very few people go on to commit serious crime during the pretrial period. Relatively, the amount of pretrial rearrest is relatively low, but among those of the serious crime, the kind that we really care about and that is deeply important for us as a society to prevent, so important that you might take a gamble on taking away the freedom of somebody who is presumed to be innocent, those are uncommon. So there's a few words.
So I'd like to just amplify a couple of the things that you said, Megan. So first of all, one of the things, as judges may be stuck with the system that currently, as it currently exists. I think sometimes in these decisions, we tend to make them be very one-sided about, kind of risk and are people going to commit pretrial crime. I think one technique that judges can use is to think about that question of what's someone's capacity to pay, what are their means, can we tailor the conditions? I remember speaking with one judge in Harris County when we went down there to, kind of preview some of our results, and she said, gee, what I would really like is some sort of a tool that would help me know what someone's ability to pay if I felt that it was appropriate to impose some sort of bail would be. Why don't you give me a tool like that? And I think thinking more seriously about, what are the individual characteristics. Ultimately, I agree that moving towards a system where judges have more information would be helpful. I think another thing that I'd like to just amplify there is, I think one of the challenges in the narratives here is that, we think about the person who we release and they tragically shoot the police officer. But what the research shows us is that there's this other side of the coin, and it's not so easy to make the causal attribution, but yet what the data show us is this occurs, and that's the person that we detain, and as a result of that detention, at some future point, they're going to commit additional crime as their life unravels. It's not so easy to kind of point and say, hey, the reason that this additional crime occurred is because of those detentions, but what the data show us is that that's a real part of the story as well, and we have to recognize that that's out there.
I would like to ask the panel, how many states have passed some kind of reforms, and are there any real promising reforms that have been passed thus far?
So, there's a lot of jurisdictions that have proposed reforms. I think some of the largest states include New Mexico, Maryland, New Jersey. California, of course, is in the midst of a reform, and there have been proposals in many places, Texas. I think the New Jersey reform is an interesting one. I suspect Jeff might have some differing views on that. The data that I've seen from New Jersey suggests that, so for those of you who are unfamiliar with the reform, there was a constitutional amendment passed a few years ago, which resulted in the state at the beginning of 2017, moving from a predominantly commercial bond cash-based system to a system where there essentially is no cash. They created a new pretrial services organization which does assessments applying the Arnold risk assessment tool as well as some other factors. They make a recommendation for the judges, and then they have the choice of either preventatively detaining people, which the data I've seen suggests occurs for about 20% of defendants, or applying various types of supervision conditions, or releasing people on recognizance. So the data I've seen suggests that the pretrial population has fallen by about 30% in New Jersey since they implemented that reform. And if we look at crime rates, right, so violent crime in 2017 down 5.7%, overall crime down. So, we have to be careful in inferring, but there isn't a lot of prima facie evidence to suggest that that's kind of gone terribly wrong in terms of, a large reduction in the pretrial population, but we don't see obvious evidence that that's kind of rebounded in terms of worsened public safety.
So I would just say, to New Jersey, my saying is, well, I have two famous sayings. One is every government program succeeds, and if it doesn't, it's because you didn't give us enough resources. And my other favorite saying is everybody loves judicial discretion until they lose. But New Jersey, and I've talked to an NPR reporter in Philadelphia about this numerous times, they have the data. They know, but they don't want to release it. And we have fought for the data. The system was implemented on January 1st of 2017. And what's the failure to appear rate in New Jersey? What's the new crime rate in New Jersey? Jail populations have dropped under bail reform, dropped more the year before bail reform, largely because of changes in drug laws. Things I've seen that work and things that I advocate for are, if you're going to OR somebody, try to find that out before you arrest them. Go to cite and release policies. If you know this guy's a first-timer and he's not going to get bail, why are we bringing him to jail in the first place? He gets in a fight with the cops, we have all this other problems. So let's identify that population that doesn't belong in jail in the first place. And I met with the Coke Industries people about a month ago, and they stopped me in the middle of the presentation. They said, Jeff, what should the bail system be, in your view? And I said, it's pretty easy. We've got this limited pool of preventative detention here, so whatever that happens to be, capital cases, blah, blah, blah. Then there should be bail, then there should be OR release, and that should be it. And we should take the bail system back to the future in that respect. And while we argue that bail has a terrible impact and that it's widely used, the reality is that people released in felonies in the 75 largest jurisdictions, it's only about 35% that have to post a financial condition of bail in the first place. And so identifying when bail is appropriate and when it's not, to me, is the game. Getting rid of all this other stuff, I think, is what we need to do because, as we said, new crimes while on bail are low. We're not going to prevent them. It's 5%. It's 5% in felonies that commit new crimes. Well, and the time periods are short. The idea that we're going to completely change the criminal justice system by supervising misdemeanor defendants for 21 days till they plea or whatever is ridiculous. And it's a complete waste of resources, and it's an insult to the presumption of innocence, at least in my view.
So I guess kind of the question I'd have for you, Jeff, or the thing I'd think about in your system is, how do we deal with the situation where we've decided that someone is bailable, but, when it's me and I have the $5,000, then I'm released, but when it's someone else who doesn't have the money, then we're detaining them. Do we comfortable comfortable with that? Is that?
Well, I don't feel comfortable making that decision because I don't have a black robe. But I have confidence in people in the black robes that they make those decisions and they do it well. And I just met with the candidate who's running for Attorney General in Florida. She's been a judge for the last 10 years, and she said, I deal with this problem every day. I deal with this problem every day. And you can say that it's preventative detention in another way. I think of it as soft preventative detention versus hard preventative detention because it's a flexible decision and it changes. And so I trust judges to make that decision, and I don't trust the system, as the professor sitting next to me has said, to flush that out right now. And I think we need to flesh it out. And when I became an attorney representing police officers for 4 years, I got a call, and the call was, hey, Jeff, we need to deal with this bail issue. So I said, well, what the hell am I going to do about that? So I went over to the senior partner's office and I said, hey, I got a bail issue. And he goes, have you called Joe Beanie? I go, who's Joe Beanie? The bail bondsman. He handles it. We never talked about bail. We never talked about bail in law school. We never talked about bail when we were defending police officers in criminal court because it just wasn't an issue. And I think that's probably something that we need to realize is that the decision to detain and detention and the length of detention in 2018 is too long. And the other thing is that we don't advocate for, that I would advocate for, that I haven't raised, is speedy trials. I represented the Colorado judicial branch for 5 years, and the time to disposition had remained stable for many years, and we were proud of that it wasn't increasing, but it sure as shit wasn't decreasing, and it should. Because and as Professor Freed said when he was arguing against the Bail Reform Act of 1984, don't do that, do speedy trial, because it's the most bipartisan, uniform, non-discriminatory way to reduce all of the evils that we want to talk about in this system, whether it's incarceration, being on bond, all this sort of thing. And why in the hell can't we do that? And I haven't figured it out. With all these new computers and all this kind of stuff, we still can't exchange discovery. We can't speed up the criminal process. And fundamentally, I can't understand why, but I think we need to look at that.
Go ahead, Walter.
Yeah. This is an issue where I'm very glad we have the laboratories of democracy, as Brandeis called them, in that states have marched off in a number of different directions, reform-wise, and of course, smaller jurisdictions have too. This is going to be extremely valuable information for us. Beyond that, there's the federal example, and of course, we've had quite a while now with the federal example, which has not collapsed and has not failed. Now, I think Jeffrey may have been getting at a possible angle of non-comparability in that federal crimes tend to be bigger and more important, and so it's more worth investing in the various mechanisms than it might be for misdemeanors in state court. Nonetheless, we have there a lot of experience with something that there is no great call to go back to the old system. I do want to push back, and this is a complete change of subject that I'm trying to smuggle in here. I want to go back to the theme that has come up many times, which is that the problem with letting cash bail be any part of the system, even a voluntary one that is at the defendant's discretion, is that it would give us a system that works better for those with money and connections and good advice. Now, I know that all of you in this room will be shocked that any aspect of our legal system would work better for people with more money, better connections, and better advice. It's just unheard of. I mean, this is crazy talk, that we would let any part of the American criminal justice system be shaped by someone being able to afford more than the next person. And yet, when I talk to my criminal defense lawyer friends, here is where they get, and they have various ways of saying this, but they point out that the public does get very, very mad at the idea that wealthy criminals, or worse yet, wealthy repeat criminals, get access to such good legal support and, of course, can get themselves bailed out. This is part of why we got the Salerno case. It was a case about the Cosa Nostra, the model of where people get very upset that justice works differently for them. And yet, my criminal defense friends say, watch out for proposals which roll back defendants' rights based on anger against the affluent ones, because it may take away defendants' rights in cases of people who don't have much to begin with. You may wind up having rolled back everyone's rights. Wouldn't it be a better ideal to level upward so that some of the people with no resources can get some of the things that you currently get if you have a decent private lawyer? Now, being criminal defense lawyers, they exaggerate their case. I wouldn't actually want all of the things that they get away with, all of the delays and all of the procedural nonsense that some criminal defense lawyers paid very heavily to do. And yet, if the truth is somewhere in the middle, then we do need to be careful. The algorithms themselves, I think, are showing us the lesson that an algorithm that is good at predicting reappearance and the various other things that algorithms need to predict will, in fact, have lots of correlations with economics. So that leaving aside race and demographics, the fact is that someone who has held a steady job for 10 years and owns a car and house is a better risk for reappearance. Does the algorithm recognize that? If no, then it's throwing away valuable information. If yes, then you have re-imported the well-off doing better out of the system.
I just wanted to say that, in truth, when you look at the factors that are most influential in the algorithm, it's really just two. It's age. Pretty much anything you're predicting, younger people are at higher risk of the bad things. And it's a history of the bad things. So if it's failure to appear, it's history of failure to appear. If you're trying to predict future conviction, it's number of prior convictions. And I don't disagree that if you've held down a job, I don't disagree with sort of like the fundamental premise, but when you actually look at the data, it is not that much of a predictor compared to these two main factors.
If I might,
Go ahead,
just
Jeff.
on the algorithm issue, it was meeting with a member of Danny Davis's staff on the algorithm issue, and I like to tell stories. So he said, well, give me an example of the factors. And as the professor said, age at first arrest is the number one factor, not age at first conviction, age at first arrest. And he just started shaking his head, and I said, what? And he said, well, my mom got a new moped, and I hijacked it and went on a joyride when I was 13, and I got pulled over by the police, and I got arrested. And I went down to the station house, and are you telling me that I'm high risk for the rest of my life? And I said, yeah, you are. And that's, and as Professor Fried said in 1981, wouldn't it be unfortunate if hours after arrest, based on flimsy information, we labeled somebody as dangerous, a label that no subsequent trial could remove? Wouldn't that be unfortunate? And that's the system we have in the federal government right now.
Okay. I think it's time for us to open it up to the floor for questions. So I see we've got some hands up already in the back, those with the microphones, if you would. You're over here, and then if we have some more microphones, hopefully, and get these folks over here on the other side.
Professor Heaton, you showed some charts that demonstrated that those who were detained were more likely to be convicted and also have longer sentences. Yeah, what I wondered about was, isn't one of the factors that the judge is considering when she sets the bail is the strength of the evidence? And isn't that going to make it more likely the person is going to get convicted? And how do you control for that?
Yeah, so again, the research designs here are designed to actually exploit random assignment of defendants to judge. And so what we would think is that the quality of the evidence, if we have a true random assignment system, shouldn't vary from judge to judge. But what ends up happening is because judges have idiosyncratic tendencies with respect to their decisions regarding detention, that ultimately leads to difference in those otherwise randomly determined and therefore similar pools that generates differences in detention, which can be used to measure these effects. Now, I should mention, however, that one of the mechanisms that we think lay behind this, so for example, the study that Megan and I did was focused in particular on misdemeanor defendants there, right? And so here's a situation where if I get detained for a few days, now the district attorney comes and says, gee, this was a kind of a minor altercation in the bar. You've already spent 4 days in jail. That seems like punishment enough. Go ahead and if you're willing to plead guilty, we're happy to accept time served, and that'll be the bargain there, right? So there, now if I want to assert my innocence, I actually have to prolong the amount of time that I'm detained. So one of the mechanisms that we think probably happens here is that people, as they accumulate more punishment in pretrial detention, it actually induces people who, in other circumstances, might want to fight their case instead to go ahead and plead guilty.
Well, that's the delay that was spoken about, but I guess I'm still not understanding. When I set a bail, I get a fact-based criminal complaint that tells me, it may say there's a statement to the police of admission. It may say that the police were eyewitnesses to the incident. There may be all kinds of accusations in there that make it far more likely that this defendant is going to get convicted. And you can bet that's a factor that I rely upon when I set that bail. And I just don't know how you control for that in your figures.
So the way to understand it is we're not directly comparing people who get detained and who get released. We're comparing different pools of defendants who are randomly assigned to different judges. We can talk, and I think it's a reasonable question, but it might get into a little bit more detail about the methodology here. But the way kind of intuitively I hope you'll think about this is that what we're trying to do is something similar to the randomized controlled trial that you might get to figure out what the effect of, say, a pill is on outcomes. And we're using the random assignment mechanism.
Yes, over here on the right-hand side.
This is, as a general jurisdiction child judge, this is one of the most challenging issues you face because as defendants come in, you've got to make snap decisions, try to get as much information as possible. One of the challenges that I get when I'm the bail setting judge in our jurisdiction, which we rotate, is the statement by the prosecutor, we won't use a summons, but we need to have a warrant for their arrest because they're homeless. And on the one hand, it makes sense because they can't mail out a summons to get them to court. But on the other hand, it seems to be economic discrimination because this person can't afford to have a home. They need to have a warrant for their arrest to assure their appearance in court. I'm interested in your comments on that. The other issue is, as the other judge mentioned, is when you're setting bail or dealing with OR release, you're trying to deal with two issues. One is chance of reoffense, and second is chance of failing to appear. And the more strong the evidence is of the crime in the probable cause statement, then the more likely you are to set a higher bail because of that risk of committing a new crime. And so it seems to me that when you have that, when you're trying to assess, you're more likely to set a higher bail when the evidence appears to be stronger and the crime appears to be a person crime with not just a property crime where there's a real risk to society. So I question whether the process itself, judges deciding to hold people who are more risky to commit new crimes, could result in those figures that you have.
Since this is the second question on that topic, I just wanted to give a slightly different version of the explanation that Paul Heaton gave for the research design. Let me simplify it a little bit. Let's just imagine you have 200 defendants, and you randomly split this group of 200 into two. You got 100 defendants over here and 100 defendants over here. Now, you randomly split them into two, so on average, we expect that the two groups are going to be pretty similar. On average, the severity, the evidence in each group is going to be pretty similar. Now, let's say you assign one group to have high bail amounts and one group to have low bail amounts. Now, the people that have high bail amounts are going to be more likely to be detained than the people that have low bail amounts. Now, what I just did was kind of give you the story of if you have a group of people, let's just say there's two judges that have a rotating schedule or something. One judge might have a preference for higher bail, the other judge might have a preference for lower bail. So you take these two groups of people that are otherwise similar in all ways, give one to a judge that is relatively strict, sets higher bail, they're more likely to be detained. You send the other group to a relatively lenient judge with relatively low bail, less likely to be detained. These two groups are going to be, on average, statistically pretty close to identical in all ways, except for one group is more likely to be detained pretrial. If you find that the group that is more likely to be detained pretrial is also more likely to have been rearrested within the next year, then we can infer that this is due to pretrial detention and not some other difference, such as evidence, because on average you started off with two groups that were identical in all ways, except for their propensity to be detained. Does that make sense? Yeah, exactly. So that you'd use the same method to say, does this group that is identical to the other one, except that they're more likely to be detained pretrial, are they also more likely to plead guilty? And which is something that we do find. If you're more likely to be detained, you're more likely to plead guilty. So that's the intuition behind the research design.
I would just add that Professor Fried, who, my hero on this issue, once said that there is no perfect bail decision. None of them are perfect. And for the homeless issue and the mental health co-occurring disorders, substance abuse, those aren't our clients. These people that are in there, and we need to do something about that. And that starts with resources for the court system. The complete under-resourcing of our system of criminal justice is an insult to everybody sitting in this room.
Yes, this gentleman.
Yes, the federal statutory scheme for bail seems quite reasonable to me. It's based upon one of the principal things that a judicial officer is not permitted to impose any financial conditions of release which result in the pretrial detention of a defendant. It also goes on to say in subsection G, this is Title 18 U.S. Code, Section 3142, that the judge must take into consideration the nature and the circumstances of the offense, the weight of the evidence against the person, the history and characteristics of the person, and the nature and the seriousness and the danger of any person to the community which would be posed by the person's release. There's been a lot of emphasis concerning whether or not bail should be set to guarantee the person's appearance, but there's a heavy emphasis on whether or not the person's going to be dangerous. This scheme, in my view, is very fair, very well thought out, and it seems that the panel really is complaining about the administration of justice, not the statutory scheme of bail. And so my question is, does the panel recognize that there may not be a systemic problem with respect to the statutory scheme, but in the administration of justice, as Mr. Heaton pointed out, there's a lot of disparity in the way judges apply. I made a comment earlier in this seminar concerning the political nature of bail settings. So I'm asking if the panel recognizes that this is really an administration of justice problem and not a statutory issue.
I would agree with you on that. The only thing I would say about the federal system is the cost. The speedy trial requirement, you got to try within 90 days. I mean, what state system could try everybody within 90 days? What state system could prove by clear and convincing evidence in all cases whatsoever that they're a danger or flight risk, otherwise they get out of jail in all cases whatsoever? It's completely expensive. And then I think the best example I can give is I was in a reform panel in Nevada, And there was a federal magistrate talking about how great the federal system was. They get a 14-page report. This is great. This is awesome. And the Clark County, Las Vegas district attorney raised his hand and he said, Your Honor, how many bails did you set this week? And she said 5. And he started rattling off the caseloads. And so you always want to work for the government that prints the money. That's the oldest rule in the book.
I mean, I guess I would respond that yeah, I feel like it's kind of a mix. So certainly, I think about the example of Harris County, where part of the arguments there were, hey, well, let's look at the laws on the books, right? There's nothing here in the printed law that said we're doing. But of course, the application is we have the minute-long hearings and a lot of the due process, issues that Jeff mentioned. And so I do think administration, Philadelphia, similar challenges, where my university is located, where, I think if you were to look at some of the rules on the books, it might seem like, okay, things could be okay, but as applied, there are some challenges. I will say I do think there are some situations where the laws can be an obstacle. For example, I think one of the limitations of the old system in California that they're moving away from is it mandated that each locality publish this bail schedule. And I think what we know from human psychology is that once you set up this grid and assign a number, there are anchoring effects, and those can often be a barrier to the sort of individualized determinations about dangerousness that, I think that we want to aspire towards.
At the back?
Yes, I have actually like an economics question. Most of the discussion today has assumed that this type of cash bail system is a first-party payer system. In most cases, you have family members who are basically cobbling together their electric bill money to get these folks out of jail for a $100, $150 bond. If you have your electric turned off in Ohio, you cannot provide for your children, and it creates a situation of neglect, abuse, and dependency where your children are subsequently taken. So the fact that we are charging people these incremental amounts, does that, in other words, does that impact the appearance, of the criminal? Do you have any information on that? Because if it was, obviously we know people behave differently when they're not putting up the cash, right? I mean, so the person who's actually in jail, it's actually all their family members. And then the second point is I guess, which I didn't realize, Mr. Clayton, your organization, American Bail Coalition, is basically one of the largest lobbying groups for the bail industry. So, I'm okay with that position, but I think given that we're an academic conference, I would have liked to have seen that as a disclosure. Thank you.
Yeah, I mean, I do advocate for our industry. I'm not ashamed of that. I go back to Leary versus the United States in 1913, where Justice Oliver Wendell Holmes said the distinction between a personal and a commercial surety is mundium. I feel that we are an extension of the Eighth Amendment, and I will give you all of the records that I have. But I will tell you one thing, is that the money on the other side is much bigger than I have. I'm fighting this battle against George Soros, John Arnold, and all this on a shoestring budget, and I'd be happy to give you our budget. Sure, but I'm a little different than most of the people in the industry because I do have a forthcoming article in the UCLA Criminal Law Review on this topic. I'm not wedded to commercial bail more than I advocate for just bail. And so I got invited to go present in Kentucky because the Kentucky Chief Justice wants to get rid of bail. And I'm going. We haven't made a nickel there since 1976.
Now, can I add something on there? So this is, I also thought about it as sort of a unique, he is, I believe, the only representative of a trade organization in this event. But that highlights the fact that, so we've talked about the sort of incentivizing role of bail, as mentioned, but another aspect is that the other role of bail in this country is a sort of vigilante, privatized, some sort of combination of pretrial services, bounty hunter, et cetera. And, there are aspects of our criminal justice system that are privatized and have been for a long time. And I don't hold a sort of a priori belief that that should or should not be the case. But I will say that, to some regards, it makes me think back, hundreds of years before there were police systems, when criminal justice was enforced through this use of bounties and these sort of private vigilantes that would go out and hunt people and bring them back and get a certain amount of money for it. That's how they made their living. And I just wanted to flag that as an extra aspect of our current situation that is, that we're sort of used to because it's been around forever, but merits a closer look at what the implications of that are if we are going to have that privatized system. To what extent is it regulated? To what extent does it provide a service that, why is it privatized as opposed to, part of the public service in the same way that the law, we have a public law enforcement, we have a public police.
Yes.
One of the more controversial aspects of the federal bail system involves drug defendants, which is probably the area where there's the most disparate impact in terms of race and things like that. Have any of the academic studies shed any light on that particular niche of the criminal population and how bail in the preventive detention model works out?
I mean, the only thing I've seen is that immigration cases are getting swept into that. And I think if you look back through history, I think the crack cocaine disparity in the 80s drove a lot of this because they were drug cases and they were primarily African-American defendants. But I haven't seen any numbers, and I think that's probably a ripe area for scholarship since I'm just a lobbying hack. I don't do that.
Yes. Yes, this gentleman.
I don't know if it's mentioned. Question for Professor Stevenson. Two questions really. The sample size on these two studies, and more importantly, we've all heard a lot about the Honor Foundation's risk assessment tool, but for particularly a felony level trial court, what do you find to be the best validated risk assessment tool out there for bail?
So I can speak, I don't remember offhand your Philadelphia. So the Harris County study, our sample was about 400,000 people. So it's a lot of people behind those bar graphs. Philadelphia was in the hundreds of thousands, is that right?
I think it was about 300,000.
Yeah, so, and again, I think one of the interesting features of this generation of studies is we are typically looking at all the criminal cases within a particular jurisdiction. With respect to the risk assessment tools, I think one of the challenges is when people say, hey, they've been validated, they have a particular idea in mind, which is, we built the tool and then we applied it to some sample that wasn't used to build the tool, and it generated predictions, and we compared those predictions to what actually happened, and they roughly corresponded. Now, that doesn't necessarily tell us about, once we take one of these tools and put them out in the field, how is it going to perform? And so, I think there's still things that we have to learn about that. To their credit, the Laura and John Honor Foundation right now has a randomized controlled trial in Wisconsin where they're implementing their tool in an experiment to try and understand, does it actually, in the field, does it operate in the way that we would say? But, I think one of the challenges with the tools is we don't have as much evidence as we would like in terms of what their performance would be. And, I think Megan's work in Kentucky suggests that we need to be very thoughtful, and we need to go and do evaluation and understand that once we implement these, what are the, kind of real-world consequences.
One comment I would just make is that it's the Wild West out there. Ohio's been using an invalid tool since 2009. The high-risk categories, risk category 7, 8, and 9, there were 2 people in the sample in risk category 9 in 2008. Yeah. It has not been revalidated since 2009, and I have written proof of that if you'd like to see it, and so that's a problem. And 5 of the original 10 ORAS tools were never validated, and so I would just say that the need for validation and robust science on this is out there and is an issue.
Okay, well, I think we've come pretty much close to the end. I would like to say that there's a number of cases now percolating out in the federal courts as well as the state courts, and so we can almost rest assured that this will eventually we're going to get some constitutional guidance on this from the U.S. Supreme Court. So it's kind of interesting back, we started out talking about the Statute of Westminster of 1275, King Edward I, and Parliament got it straightened out then. Maybe at this time it'll be Roberts and Thomas, Ginsburg and Breyer, Sotomayor and Kagan, Alito, Gorsuch and Kavanaugh who will get this straightened out for us. So I would just like to thank our panelists very much for a great discussion.